All right, NSA leaker Edward Snowden says he's ready to come back home. He wants to come back to the States if he gets a fair trial. Snowden, as we all know, was granted political asylum in Russia back in 2013 after the U.S. revoked his passport. His attorney says the only guarantee Snowden has received to this point is from U.S. Attorney General Eric Holder, who has said that Snowden will not face the death penalty. Not so generous so far. The NSA whistleblower faces charges under the 1917 Espionage Act. Ben Weisner, Snowden's U.S. attorney, legal advisor, I should say, as well as an ACLU attorney, said the following. The laws under which Snowden is charged do not distinguish between sharing information with the press in the public interest and selling secrets to a foreign enemy. Edward Snowden is charged with 3 felonies: theft, unauthorized communication of national defense information, and willful communication of classified communications intelligence information to an unauthorized person. All right, so what we do here is we have 2 of the attorneys take opposite positions on that, and let's get to the opening arguments, if you will.
I have the burden of proof here. Aren't I supposed to go first?
Can you just pipe down? We go to Mayo Bartlett. He wants to even play judge, too, here. Mayo will argue in favor of lenient punishment for Mr. Snowden. Mr. Bartlett.
Edward Snowden was justified in his actions because he provided us with information that we had a right to know and that we actually needed to know. The government not only concealed this information, but it lied to us about it. Edward Snowden's a whistleblower because he exposed crimes committed by the federal government. When the government seeks to mask its criminality in laws that can only be argued in secret courts like the FISA court, people like Snowden who exposed that criminality must be protected. Otherwise, those crimes may be carried out in our name, possibly even against us without our knowledge. By releasing the information that Snowden released, he did not harm the United States. In fact, he instead damaged the politicians and governmental operatives who engaged in and facilitated the illegal activity. Snowden's revelations have already resulted in federal judges making accusations that the NSA has been violating the Constitution. Mr. Snowden was clearly justified in blowing the whistle on the NSA. In addition to the mass collection of phone data and other information on innocent Americans, Mr. Snowden exposed widespread governmental criminality. The NSA routinely broke federal privacy laws or consistently exceeded its authority, according to the agency's own internal auditor.
Thank you very much, Mr. Bartlett. And that ding-ding is the minute here, and I've had 3 attorneys speak so far, and they've all ignored the ding-ding. Let's see if Mark Furnish makes it 4 for 4.
Ding-ding.
And speaking of Mr. Furnish, he will make his argument, shockingly, for throwing the book at Mr. Snowden.
Effective intelligence gathering necessarily entails maximum secrecy. Edward Snowden turned this truism on its head, compromised our national security, and broke federal law, chiefly the 1917 Espionage Act, when he stole classified defense and intelligence information and brazenly leaked it through the media. There is no real dispute about any of this. When he went to work as a government contractor, Snowden promised, as a condition of receiving national security clearance, not to disclose classified defense information to unauthorized outsiders. Snowden not only thumbed his nose at that pledge, but bragged about doing it. In a June 2013 video interview, he practically crowed that he had given confidential documents, prominently labeled top secret, to reporters with the Washington Post and the Guardian. That damning confession, in the defendant's own words, makes this an open and shut case. Snowden is guilty beyond any possible doubt. It is no answer that Snowden and his apologists fancy him some kind of white knight or freedom crusader with honest, even heroic motives. There is no First Amendment or whistleblower defense to an Espionage Act violation, as his own attorney now admits. Not this attorney, his real attorney.
All right, gentlemen, have at him.
Mr. Bartlett, should there be a difference, should there be a distinction between selling top secret information to the enemy and disclosing it to the press?
Absolutely. If you're selling it, you're doing so for personal gain. If you're disclosing it, you're simply giving that information, again, to the press, which presumably will then be an outlet to give it to the people of the United States.
But who is he to make that distinction and that decision?
Well, Mr. Snowden was working in the government, and he observed the fact that the government was engaged in criminality and that those crimes were actually being committed against the United States citizens as well as our allies. So
Did he not have any other alternative but to disclose it to the press? And why is he so sure that the press to whom he's disclosing it is not going to damage national security.
The only way that Mr. Snowden would have been able to actually disclose it would have been to go directly to Congress, and Congress in all likelihood would have ignored him. But beyond that, the FISA court is the court that actually oversees all of these cases. That's a secret court. The people are not able to determine what happens in that court.
I'm sorry, in this day and age with this Congress, are you telling us that if he had gone to congressional leaders that were not on the side of the administration, he wouldn't have gotten any play?
Well, in fact, he could have even committed a crime by disclosing the same information to Congress, because unless the people who he was making the disclosure to were authorized to receive it, it's no less a disclosure.
May I?
You may.
Mr. Furnish, I have 3 questions for you.
Shoot.
The first one is, can you separate Mr. Snowden's conduct from the conduct of the NSA?
Absolutely. The legality of the NSA's activity is not on trial in this case. The legality of Snowden's conduct is what is on trial. He has ample other forms, contrary to my friend's suggestion here. He could have gone to the ACLU, not leak the information, say, here's what I've seen in my job, follow up on it, bring suit, just like they're doing right now in the other courts that his lawyer referred to. That's how it should have been done, could have been done. Or he could have gone to the ballot box and voted this administration out, or he could have gone to conventional law
Cut him off,
enforcement
Mr.
authorities.
My second question is, do you acknowledge the fact that this administration has barred entities from bringing lawsuits to challenge the laws of the NSA under national security grounds?
You can still challenge that bar on constitutional grounds. It happened to the Bush administration in the habeas cases at Guantanamo Bay. They're doing it right now. The ACLU is doing it. He could have gone to the ACLU, told them this is what's going on anonymously, investigate it, bring the suit. There are 3 of them pending right now.
So will you acknowledge the fact that if you couldn't bring this in a lawsuit in the courts, you had to bring it in another way?
He didn't bring a lawsuit. He leaked it to the press. He violated the law. He did exactly. You don't take the law into your own hands. You don't resort to self-help.
Let me ask you this. Did he swear allegiance to the Constitution when he took his pledge?
He swore that he would not disclose confidential information.
And did he also take a pledge to the Constitution?
What does that have to do with anything?
Because if the Constitution was being violated, which is the question here.
That's not how you test a constitutional violation. You test it through
One of the
judicial
questions, guys, that
review.
we started with, and I'm going to go to break, but it was what form of punishment should Mr. Snowden be looking at?
Well, the
Mr.
statute
Snowden-
set a limit for what
Mr.
they are, 10 years apiece.
But Mr. Snowden is facing 10 years per charge.
Yep.
And then
30
the other
total.
thing, though, is that he's been assured he's not going to have the death penalty. And just the other day, we had General Petraeus, who leaked same type of information
Death
to
penalty
his
isn't even authorized for these crimes.
Well,
How
take
about
the
that?
death
That's
penalty
not-
off. I
to
guess
his
the question, we'll
girlfriend.
come back on the other side of the break, is if Petraeus got probation by exposing national security,
Well, maybe
including...
Petraeus is a war hero and actually has done something for the country, and you would take that into account as a mitigating circumstance, while this man just took the law into his own
Mr.
hands.
I
and
look at
annoyed
Mr.
All right,
himself.
we will continue this debate in the commercial break, I am sure. And you should be a part of this conversation too. Go to Facebook and Twitter. Sound off on our question regarding Mr. Snowden, who Mr. Furnish does not think very highly of. Should the U.S. show leniency or throw the book at him? When we come back, the control room will weigh in on whether or not Snowden gets the book here or a slap on the wrist.